morning, Ms. Moretti.
Good morning. May it please the court, for the record, I'm Michelle Moretti for petitioner Justin Grady. This case seems to present issues similar to that posed by the previous case. The main issue of the two that we're stressing is that petitioner's confrontation rights were violated when the trial judge allowed expert witness testimony which relied on an absent witness underlying data. Now, we can fast forward ahead and agree that in the case law has subsequently held that an expert opinion may be given by an expert, but the expert may not reiterate the absent analyst's data into the record. And the brief discusses that foundation. But however, we come to a much more clear issue where, in fact, the analyst reiterated, and it's no question that he obtained this information from a certificate of analysis which was not admitted into evidence after Bullcoming, New Mexico was decided, which precluded absent analyst testimony. They had the analyst testify, and he specifically stated that, in his opinion, the 4.4 grams of cocaine was cocaine. The powdered substance was 4.4 grams of cocaine, and obviously that specific utterance
You mean the amount?
The amount
Right.
was directly derived from the certificate of analysis, which
Is it clear here that the witness, in fact, did not weigh this himself or herself?
yes, it is clear. The witness, and in the brief, it discusses extensively of what the expert witness did not do. The expert witness only had a supervisory role and reviewed the conclusions for many drug analysts by reviewing underlying data. But the drug expert, Gagnon, had no particular familiarity with underlying chemists, Gina DeFranco's work in this case. He did not observe her. He did not train her. He wasn't specifically familiar with the work that she normally performed.
Well, if the evidence had been to the contrary, would it have mattered?
It may have in cases such as the line of cases with Barboza and I think Tessone and Greinider, the fact that one of the expert witnesses had more familiarity with the instant evidence was dispositive. I think it was in the case involving Cellmark, it was held that the expert that testified was even more qualified to testify than the person that performed the underlying test because of the proprietary nature of the technology. That was not the case here. Now, in drug lab cases where this testimony has been permitted, it's been allowed specifically when the substitute had specific familiarity with the witness's underlying work, her record. In one case, he trained her, and that seems to be the distinguishing factor. There was none of that here. The amount, so that of course goes to whether the substance was cocaine, of course, and whether its weight was what it said. And both issues are important because at trial, there was only there was no expert testimony actually, that the substance was cocaine on the part of the trial office, the officers that testify. One was not an expert witness at all. They testified that there was a white powdery substance, and that was really about it. It was.
Wasn't there something about whether this
amount, and that was the prosecutor's closing. They focused on the amount
Yes.
as being more than what was testified to his trial as evidencing personal use, which was less than 3 grams, and this is 4.4, so it must be intent. And then the jury, of course, came back with a question about that very specific issue.
Thank you, Your Honor, and that brings us to the key point. Because the jury acquitted Mr. Grady of possession of a firearm, that was one of the factors that was subtracted as indicative of intent to distribute. The evidence on intent was poor. It was so poor that even the Commonwealth asked the judge to instruct the jury on a theory of simple possession rather than possession with intent. And at trial, one of the officers testified that 3.5 grams would be more consistent with personal use rather than intent to distribute. That is a 0.9 grams. It's less than the weight of a penny. It's a featherweight. And it was only that fact that could have swayed the jury that the amount found was intended for distribution and therefore distribution inside a school zone. It could have just as easily been intended for anyone's personal use.
But was he convicted of possession with intent?
Distribution within a school zone. The
Distribution means you give it to somebody. Doesn't matter how much it is.
possession with intent to distribute within a school zone.
It was possession with intent or distribution?
Possession with intent.
With intent to distribute within a school zone. And so he did suffer the school zone penalties. But on the point, the evidence was obviously there was another person in the car who fled when he was approached by the officer.
Well, is your claim that they're applying the substantial risk standard? There still is a substantial risk here?
Well, there is a substantial risk, but there was the appeals court acknowledged this error, and they found that
there was no
harmless error because the trial counsel didn't object immediately after.
Right, so the appeals court concluded it was not preserved error, therefore it would be viewed under the substantial risk standard.
Yes, but and that's just an unbelievable conclusion because throughout this trial, from the motion in limine on, trial counsel worked to preserve this issue on constitutional confrontation grounds. There were 9 pages of motion in limine testimony devoted to this. He was denied of voir dire of the expert witness to establish his foundation. He was then, during the course of the trial, he objected repeatedly to any instance where the expert substitute was allowed to opine.
But not as to the weight.
In fact, Your Honors, trial counsel objected immediately before any question was posed regarding.
Did the prosecutor ask what was the weight?
The prosecutor did not specifically elicit that. It was a more open-ended.
An opinion question.
It was the analyst that.
Right, so it was a proper question and an answer that involved bringing in material that was not subject to cross-examination, and that was improper.
That was improper.
So the question is whether there needed to be an objection or motion to strike the answer, where a proper question has been asked.
And we would argue that in these cases, the overall objection that was repeated and reiterated throughout the trial, and the fact that the trial judge had just previously sustained counsel's objection to the extent that the expert's conclusion would rely on the analyst's notes, should preserve the issue. And my brief cites cases ad nauseum where this lack of specific objection was overlooked. In fact, in Williams, Commonwealth versus Williams, which was the unpublished decision that I relied on in the appeals court, this exact same situation presented itself. There was an analyst who testified improperly as to the specific weight. There was no objection, but the appeals court, in a different panel, held that it should be evaluated under the harmless error standard, and they reversed. So there is a serious split at that level of the judiciary. But in this case, it was the, I'm sorry, have I sufficiently answered Your Honor's
You have,
question?
thank you very much, appreciate it.
And I would refer to the brief as to the specifics. I think I have 3 pages worth of cases on that.
And I'm afraid your time is up, so you'll have to rely upon your brief. Thank you.
Thank you, Your Honors.
May it please the court, Carrie Ann Kilcoyne, Assistant District Attorney from Middlesex on behalf of the Commonwealth. The lab supervisor here offered his own opinion that the substance was cocaine. He did refer in his answer to the weight.
And he shouldn't have.
And he shouldn't have. I'd suggest he referred to it merely as a descriptive term, but he should not have referred to the weight because the weight only came from the non-testifying analyst's report.
If that were deemed preserved instead of unpreserved error, does that make a difference here?
I'd suggest no, that even though it was error, and if the court finds that it was preserved and that it's under the harmless error standard, that there would be no harm based on the other testimony that was provided in this case.
But is that because weight is not an element of the crime?
That's part of it, exactly, Your Honor. Weight is not an element in this crime.
All we have
It's-
is, it's a distribution, isn't it?
It's a distribution. He was, convicted of possession with intent to distribute, I believe.
Was it?
Yes.
Yes.
Your brief says he was found guilty of distribution.
That's not what the appeals court opinion says.
It doesn't.
The appeals court opinion says guilty of possession with intent to distribute. Is that correct?
That's what I referred to in my brief, that he was found guilty of possession with intent to distribute.
But this wasn't a hand-to-hand sale.
No, it was not. The drugs were found in the car on the passenger side, the driver's side door, and the defendant in this case was the driver of the car. So the weight of the drug isn't important because it's not trafficking. The quantity or amount of the drug, of course, has some relevance as to whether it goes to.
Personal or distribution.
Exactly.
So it was important.
It was important in that sense. I think weight is the wrong term, but certainly the quantity.
Jury, didn't the jury raise a question about
They
that
did have a
very
question about
Yeah.
possession with
Right.
intent, and the drugs weren't found on him, so that could have been part of their issue because they were found in the car. But the drug expert in this case testified about the packaging, and that's also important, is how they were packaged. That quantities for purposes of distribution and street level transactions are quarter grams, half gram, grams. That in this case, and he had the drugs were before the jury, they were Exhibit 4, and he was shown the drugs, and you could see how they were packaged, that these drugs were there were 12 small baggies with the twist ties, and those.
Did the police expert incorporate the specific weight into his opinion that this was consistent with intent to distribute as opposed to personal use?
The hypothetical that he was given included the reference to the 4.4. I would suggest that he did not adopt that weight, because his specific testimony, when he reviewed the bags, he opined that each bag was either a half gram or a gram.
Okay.
And that if you were using the drugs for personal use, you wouldn't buy, for example, 7 half-gram bags for $50 each, when you could buy an 8-ball, which is 3.5 grams, for $150. That drugs are packaged this way for the specific purpose of
Selling them.
distributing them. Yes, selling them.
You mean you couldn't get a drug distributor at the end of a day hadn't sold all of his little packets and It's sort of like going to the butcher shop, you know, they clear out all the meat
Right.
at a
Or get a
discount. All the
sale.
individually cut pork chops.
I suppose it's possible. Of course, his testimony was that the drug dealer, the drug dealer seller wants to make as much money as he possibly can.
I know,
And
but it's the end of the
so-
day, he's tired.
Well, I mean,
Wasn't
this
there
could have been the
testimony, though?
beginning of his day. I mean, it was 12:30, but in the
Wasn't
morning.
there testimony from somebody else about what was indicative of personal use, the 3 gram, 3.5 grams?
That was the drug expert. He's the one who mostly talked about the 3.5 was more personal.
Right,
The,
and
the,
wasn't- Right, so if that's more related to personal, then the weight, if it's more than that, is important.
But it's more the packaging, is what you're saying. Is that right?
Well, that's part of it.
yeah, I mean, I think it's certainly part of it, and that was part of,
Closing, wasn't it?
I'm sorry, Your Honor,
Was that the full focus at closing?
for the Commonwealth.
Yeah.
Again, the prosecutor did mention the weight again, but I would suggest that in this case, the jury were instructed that the closings weren't evidence, that the questions were not evidence, and that the drug expert's testimony, you know, would be more weighty than either the hypothetical or the closing argument, where he had over 20 years' experience in the drug trade. As a police officer, he did undercover. He explained what drugs look like, again, how they were packaged, and I think all of that comes into consideration.
In connection with the packaging, how many of these packages were there?
There were 12.
So does the number of the packages have any significance?
Absolutely.
So it's the packaging including not just the quantity per package, but number of packages?
Absolutely. Yes, absolutely, Your Honor. There were 12 small bags within a larger bag, and there was also testimony that they were packaged in a larger bag because if a dealer was pulled over or it was possible that they would swallow the larger bag to conceal the evidence if they were caught.
It was, when the expert was testifying to, you know, that it was distributed in 1 gram or half gram, the packets,
Yes,
was that, it was a he, the expert?
it was a he, yes.
Did he say they are that, or that's what they look like? I mean, because he didn't have any independent knowledge of weighing them, right? Of what they-
Correct. He did not have any independent knowledge of weighing them. I believe his testimony was that in his opinion, I'm just trying to see, in his opinion, they looked to be either a half gram or a gram, and the specific page would be volume 4, page 54, was his testimony about that. So for all of those reasons, Your Honor, if there are no further questions, I would rest on my brief.
Thank you.
Thank you.
Thank you.